New updates in the case against Steve Bannon being brought by government prosecutors for his refusal to go and testify in front of the January 6th Fake Select Committee. They're very upset with him for not complying with this investigation. They charged him with crimes. Now his lawyers are firing back. They are demanding two things. Number one, that the government provide a bunch of additional discovery. This is disclosure. This is stuff that Steve Bannon, according to his lawyers, say that he needs in order to defend his case. And they're also making an argument that, Steve didn't actually willfully deny or refuse to comply with the law. He was just following the advice of counsel. Of course, that is protected. The headline we're going to jump off from comes over from CBS News. It says, Steve Bannon claims that he didn't willfully commit a crime in defying congressional subpoenas. And so let's take a high-level overview of what this is sort of talking about. Remember, in a crime, most often in criminal charges, you have sort of two components. In law school, they teach us about this. One's called mens rea, which is your mental state, sort of the mindset that a person is in. And the other is what's called actus reus. This is the action. And so, for example, before you can kind of, commit a theft, for example, right, you got to have to sort of want to steal something, take something that is in somebody else's possession and take it away from them without paying for it, walking out the store, right? You have a physical act. You have the act of taking the item and walking out of the store, but you also have a mental state, somebody who says, oh, I'm going to take that and not pay for it. And so you're sort of connecting the two. Here, Steve Bannon is saying, look, I didn't willfully deny anything, right? I was following the advice of counsel, and the advice of counsel is something that's very protected in this country. And how can you be breaking the law if you're just defending yourself in compliance with what the Constitution provides? It's a great question. Steve Bannon, the former White House strategist, who has been charged with criminal contempt of Congress, issued a court filing that argues he's not guilty because he was just following the advice of his lawyers and he didn't know he was committing a crime. How could I know if I'm committing a crime if I call my lawyer? My lawyer says, no, you're not committing a crime. Just do things this way. The charges stem from his refusal to testify and provide documents to the House committee investigating the January 6th assault. His lawyers, according to this article, advised him not to show up for the interview with congressional staff or turn over the documents. And so Bannon said, look, on January 6th, folks, I was not even employed at the White House and hadn't been there since 2017. We go over to the court docket. We can see there are a slew of updates that came across this month in February. And we've got a couple, really one that we're going to take a lot of attention to. This one filed on February 4th and then followed up on, you're going to see, by a slew of different responses. But here, this one's interesting. This is the motion to compel discovery. Now, this is a motion. You can see here it's got a whole slew of exhibits. It is a big motion, and it is about 28 pages long. You can see that up here. And you can see this is the defendant's motion to compel discovery. So this is coming out of Steve Bannon. His attorneys are filing this. And they're saying, Judge, the government has a bunch of stuff, big files, big binders, big stacks of paperwork that we need access to. It's called discovery. If you're charged with a crime, well, there's going to be a police report, there's going to be body cameras, there's going to be surveillance footage or 911 calls or witness statements or blood result, whatever. There's a lot of discovery. And the defense needs that in order to defend their case, in order to figure out what the charges are and what the government's evidence is. Well, we got to be able to rebut that. If they're saying witness A said this, well, we got to go and make sure there's some evidence and to try to contest what they're alleging. Big document. You can see 28 pages. These are the gentlemen who drafted the item. You can see Evan Corcoran, somebody out of the D.C. bar, Washington, D.C., and then David Scone. Now, you can see this photograph, is the attorney who actually argued on behalf of Donald Trump during his impeachment. And so these two fellows drafted this motion. It's 28 pages. I just clipped out some of the pertinent stuff. And remember, we're sort of making this argument that Steve Bannon, his constitutional rights are being trampled all over the place by the federal government. And he's asking the court for help. I need access to those files if I'm going to be able to prepare my defense. And he also says, by the way, as we're sort of looking for these documents, kind of becomes evident that maybe they did some misdeeds in this entire investigation that justify a dismissal of the charges. Let's take a look here at the introduction. And they're notifying the court, and they've got an interesting intro here. They say, Judge, to prevail on a motion to compel, which is what this is, to get those additional files, We don't even need to prove that that evidence is going to be admissible, all right? So we don't have to say anything about that evidence. If you're going to say you can only get access to evidence that you can get admitted in trial or in front of the court, that's not the rule. They're saying the burden is much lower. We only need to make a showing that this information sought would tend to help in preparing a defense, okay? That's it, low standard. Just tend to help. Doesn't have to be admissible. It just needs to tend to help. And they're telling the court, look, judge, when we filed our discovery request, they were specific. They were tailored to the charges in this case. We weren't out there doing this big, broad fishing expedition. It was very focused. Our 7-page letter provided controlling legal authority, and we requested 30 very specific categories of information. The government's 3-page response said that they don't have anything to show. Okay, we put 30 pages together. The government responded with a 3-paragraph response. That's all that we've got. That curt response, they write, mirrors a scene from John Huston's film, The Treasure of Sierra Madre, where an American character played by Humphrey Bogart questions the legal authority of a group posing as law enforcement agents only to get the reply, badges? We don't need no badges. I don't have to show you any stinking badges, right? It's like we're the government. We just are in control. We don't have to show you anything because we are the government. Well, that's not how it works here. Bannon's lawyers are saying we need access to that stuff. We've got a list of 30 items, 30 broad categories of items that we need. Please give it to us. If you've been paying attention or following this channel, paying attention to this story, we have gone through lists of the discovery requests that came out of Liz Cheney and Fishing Benny Thompson, the chairman of the January 6th Select Committee. They had dozens of pages of everything. I mean, they wanted to know what you had for breakfast on January 5th. So Steve Bannon's lawyers are saying, look, they demanded all this from us. We need to know a lot more about them. Let's see what this says. It says, when an accused faces federal criminal charges, the government cannot ignore legitimate requests for information. We've got to prepare a defense. The authority says, though, and a key aspect of the discovery rule is the government must disclose information that would allow it to prepare a defense, right? Can't avoid its discovery obligations is what this says. And the government has an obligation, they write, to conduct a broad search. So in addition, right, the government can't just turn around and just say, well, we can't find anything. Well, we have a list of 30 things. Can you please we searched for them and we can't find them. Well, how hard you look, really? Here, this is saying they have an obligation to conduct a search for information that tends to be inconsistent with the defendant's guilt, negate an element of the crime, mitigate the offense, establish a defense theory, anything, right? And remember why this is so important for the defense. Well, it's because we don't have access to that information, right? The government holds all the cards. They have the briefcase and the files. And so if they don't give us the information we need, well, we don't ever get to see it. And so we're sort of trusting them to act in good faith, to go through and make sure that they're identifying stuff that might be problematic for their case. Do you trust them to do that? So they are now demanding, they say, we respectfully request this court compel the government to meet its obligations. And I want to show you a couple things. They say, we requested items about the grand jury related information. Look, Judge, this is all the stuff we asked for that they're not going to give us. All documents regarding subpoenas about the investigations related to Bannon. So if you're investigating Bannon and you're subpoenaing person A, B, C, D, and E, and F, and you're Steve Bannon's defense lawyer, don't you want to see those documents? Yes. Who else did they subpoena? And what else did you get as a result of those subpoenas? All subpoenas and investigative requests related to Bannon or any person acting on his behalf. Similar, all things about affidavits related to Bannon. We've got any matter about how the grand jury was charged, right? What the instructions that were detailed to them. Want to know what those were. All documents and information of any kind presented. All documents obtained as a result of the grand jury subpoena, but not presented to the grand jury, okay? So did you get a bunch of stuff that you're like, oh, this is going to be really good. I can't wait to get our hands on this. I can't wait to show this to the grand jury. It all comes in and you go, ooh, actually, that's not so good. Okay, well, we're not going to show that to the grand jury. We're going to show them the other stuff. That's what Bannon's lawyers did. Well, can we see that? What was in there? Because if you didn't show it to them, but you got it as a result of those subpoenas, well, maybe it's got some exculpatory information in there. 27, all documents and informations reflecting consideration of or any presentation of anything that went to the grand jury that would negate an element of the offense. Okay, so a criminal charge is sort of like, stacking a bunch of true statements together. So somebody did this check, did this check, did this check. They're saying, does any of your evidence, it might not sort of rebut the entire crime, but does it rebut any one of those check marks, any one of those elements? If you've got to prove A, B, C, and D, does something negate C? We got to know. All documents, all information about the credibility or accuracy of any other witness, right? Any counsel that was involved, and you're relying on their, lots of stuff. 28 pages, there's a lot more here. But they talk about the purpose of the rules. You can see, grand jury witnesses need to be truthful. The reason why they're supposed to get that is to prevent the grand jury targets from interfering and to protect suspects who might be later exonerated. Right? There's rules for this stuff. Here, the government, they're saying, has sought and obtained authorization for the disclosure of selective portions of the grand jury. It should not be permitted to argue in secret. Right? This stuff, there's rules why this is important so that grand juries are honest and truthful. The defense wants to see those things because we don't just happen to take the government's word for it. If something went bad in the grand jury proceedings, maybe he wouldn't have been indicted in the first place. They say the defense is entitled to a full picture of what was presented, what was not presented, how the prosecution characterized the evidence and the charges, and the instructions that were given to the jurors on how to apply the facts and the law. They're writing, there's no legitimate basis for the government to selectively disclose what they want to us. And I totally agree with that. They go through a couple different subjects here. We see they are also asking about some documents and explaining the reasons why Bannon could not comply. Here you can see. In this and subsequent communications, Mr. Costello explained the reasons back to the back to the select committee about why Mr. Bannon could not legally comply with the subpoena. Okay, so what this is telling us is that the subpoena came in from the January 6th Select Committee, and they were demanding that Steve Bannon do X, Y, and Z. You have to come up here and show us whatever. And he said, I'm not going to do that. Why? His attorney was communicating, look, he's not legally required to comply because we have certain rights in this country that protect the presumed innocent. And you don't get to just sort of demand that they comply with everything without legal counsel. Right? We don't live in a dictatorship like in Canada. And here it says, these included, but were not limited to the following conversations. President Donald Trump, through his attorney, instructed Bannon to protect information covered by executive and other privileges, right? Other legal bases for not complying with a subpoena. Trump's attorney also advised Bannon that Trump was prepared to defend these privileges in court. Costello advised Bannon that, quote, will comply with the directions of the courts and they're going to rule on the issues about attorney-client. He's giving legal advice to his client. And he's saying that those are partially reasons why Bannon is not complying with the subpoena. He continues on. He says information also might come out if in this discovery that tends to show that the subpoena was not even lawfully authorized. Okay. He says the prosecutors in this case must prove beyond a reasonable doubt that the subpoena that came out of this fake select committee going after Bannon and others was even valid and issued pursuant to lawful authority in the first place. How can you violate a subpoena if it's a fake garbage subpoena that's just made to go after your political opponents? We are also entitled to any information that tends to doubt credibility or cast doubt on the accuracy of any evidence. Continues on, says no criminal prosecution would have followed but for the actions of the select committee. They passed a resolution. They created a record. They drafted this subpoena. They came up with the whole thing. Before you can move forward, you got to make sure it's a justified prosecution or has a foundation in the first place. So now they're respectfully requesting the following. All documents about the establishment of the select committee. Do you see how this is flipping the other way, doing the old switcheroo, topsy-turvy this thing? You can see its membership, its staffing, its budget, its authority, and the authority of the select committee to issue subpoenas. So Bannon's lawyers are saying, all right, well, look, you're saying you had a valid subpoena. You've got the burden of proof. You got to prove this beyond the reasonable doubt. So how about you give us all the records about your committee and how you created your subpoena and where that authority came from? They're also asking for all documents about the membership, staffing, budget, and authority, everything related to the appearance of Bannon as a witness, all information in possession of the House of Representatives Rules Committee, the Office of Counsel, the Office of the Speaker about Mr. Bannon's appearance, right? What's Pelosi been saying about all this? All the documents and information from the Select Committee about the subpoena, emails, interior emails, any conversations with the U.S. Attorney's Office, etc. Conclusion. As a result of all the things we just said, Mr. Cochran and Scone respectfully request an order compelling the government to produce the requested discovery materials so that he can prepare a defense to the charges in this matter. And so, right, this was the baseline kind of theme, arguing that Steve Bannon and his defense have no real access to build a defense and making a counter response and a counter demand. And so the government is responding, has responded, and then Steve Bannon is going to have the opportunity to issue a final reply. And so we're going to continue to see sort of what the judge rules on and how the judge interprets these arguments and how they rule on this, because this is kind of a unique case. You know, we have this select committee that was created by Congress, and they gave themselves, a whole slew of powers. They demanded a bunch of people do a bunch of things, but now we're actually in a real court of law where we actually have due process and the presumption of innocence and legal precedent. And we'll see how the judge applies it. I'd love to hear what you think about this. You think the government's going to give old Steve Bannon here anything that he demands? Or are they going to just sort of continue to beat this political dead horse until maybe after the midterms, until Donald Trump goes away? Who knows? We'll see. But I'd like to hear from you. What do you think about Steve Bannon and the prosecution against him? Let me know down in the comments. I hope you hit the subscribe button before you get out of here. We have a live show that we do weekdays, and I hope to see you there. I look forward to seeing you on the next one.